Right. Mr. Gallo.
Thank you, Marlon. I would, with your permission, address a few points that we addressed before the break.
Yes.
And then I'll come to my final concluding submission. The question was asked about the evidence of the defendants regarding the land and the house. So for this purpose, I would refer to the English translation, which is found at page 372 of the record.
Yes.
Yes, where you would see that he was talking about the land in question, and he said how it was planted by sugarcane at page 372. So he explained this. So how it was, the father was planting. And then if we look at page 373, he explained about his sister, his brother and himself, and about the land, the road that were around the land. And it was further down at page 374, he again said about the three of them in the middle, Krishnauti, Domun, and the rest. And prior to that, he referred to his neighbor, Deodat Padarat. And also, he deponed regarding the title, so how he obtained the title from his father, and also how the father got from their predecessors. And I, therefore, would not need to refer to the document concerning the land, which is at page...
Well, before we go there, can we please look at what the evidence says? At the bottom of 372, a question is asked, have you yourself ever occupied that land? There's an objection on the ground because there isn't a plea that he has been occupying, and the question is withdrawn. Do we see that?
Yes.
Yes. And then he goes on, and the question that's asked further down the page, do you know the land of the 37 3/4 purchase? Can you tell the court who are the neighbours who reside near that land? And the answer is we ourselves, my sister-in-law, my brother, and myself.
Yes.
They're not claiming there that they occupy the land.
But their claim throughout has been that they've occupied the whole land. And there was dispute about sugar canes, about who planted and who was that part that was covered with sugar canes. And I referred to that earlier.
Yes, but do you not see, I mean, the question that's being asked and what has been discussed there is about who are the neighbours, who has property bounding that land. That's what the discussion at the bottom of 373 is about who are the neighbours. Do you accept that?
Yes.
Yes, thank you.
And he said there were two roads, and then there was they were themselves there, occupying the land, and then there was Deodat Padarat.
Yeah. Anyway, you're going to show us the evidence on which you rely as showing that there were houses built on this land. Is that right?
Yeah, but this house was not situated as such, was not neither by the plaintiff nor by the defendants. They didn't bring any picture, anything about the house. And this is why I was going to refer to the title deed, which says, and the title deed, we have the land of course, of 87.5 purchase.
Yes,
the total
but let's
land
stick with
where
the evidence. Is there anything else in the evidence that you rely on that you want us to refer to?
I was going to refer to the title deed, and then the title deed, which is found at page 193, 195, document R.
I was going to say, they didn't produce any photographs of their house on the 37.5 purchase, anything like that?
Yes, there's no direct evidence as such, because they were saying it is same land where there were 3 houses.
Yeah.
But then the delimitation was not given, of course. They didn't give the delimitation. And also, there's nobody who came and testified where the house was situated.
Yeah.
And then when the plaintiff was claiming to have planted sugar canes, they didn't give their delimitation as such. No documents that were produced would give the boundary lines of the land planted with sugar cane.
Yeah.
So that you may have a land, and I was referring to that, you
Can
plant
we
sugar
take
cane
this
and
in
then there are
stages?
options.
First of all, there's no further evidence in the transcript that you want us to refer to, as I understand it,
Well,
right?
there's further evidence, but is there further evidence supporting your assertion that houses are built on this land? Because, can you look, please, at
Apart from
381? Can you look, please, at 381? At the bottom of 381. But you lived near. There was sugar cane all the time on that land. Today, is there sugar cane? Yes or no? Yes. There was sugar cane all the time on that land? Yes. Who was harvesting it? I believe it was my father. And then he's asked, do you have any document to the effect that your father was harvesting? And then an answer is interrupted. Not what you know. Do you have any document? That I cannot tell. And then again at 384, that question, that gentleman, that line 14, that gentleman who was occupying the land after 1999, and he is still occupying and harvesting the sugar canes on it. So are you aware that sugar canes on that land, it was that gentleman, then there's interruption. That gentleman who was occupying the land after 1999, and he is still occupying and harvesting sugar canes on it? No. Are you not aware? No. I knew about his father, and then there was a case in court, interrupted. No. Do you know or not? No. But who, according to you, it was harvesting the sugar canes? Myself, I don't know. So the discussion seems to have been on the assumption that what was on the disputed land was sugarcane, not houses.
Is your lordship referring to the whole land of 87 purchase or only 37.5 purchase?
Sorry?
Because the point of the defendants...
We're referring to the 37...
37
purchase, yes.
37 purchase.
And what's being said
Yes,
here is that there's sugar cane on the land, not houses. Now, what we're trying to get from you, is there any other evidence you want to refer to which shows that there were houses?
No, apart from the testimony of the representatives of the defendants, there's no other evidence of such.
Now, you wanted us to refer us to the title deed, did you, or some document? You were about to go on to some document.
Yes, the title deed, that is at page, document, the last document, at document R, at page 193 to 195, where the land is described. So you have the description of the land, you have the roads there, 2 roads, and then 2 neighbors when it was. So the point is that the title has never been put into question by the other side, by the plaintiff, now appellant, and there was no cross-examination even by the title. Whereas the defendants in the court below did depone as to that and as to the previous owners. And we would see in the authorities, the various authorities quoted, that a title deed, of course, if challenged by prescription when attacked by a plaint, then the prescription tends to prevail. Unless the owner by title could show that their predecessors in title also were owners of the land. And in this particular case, in document in question, the title deed, you would see described there how the sale was done by the father, their late father, who sold to them the usufruct. The usufruct, that is, when the father would pass away, they would become full owner. And then it says, it describes the land, and there is on the land the house under construction. Of course, I would concede with your lordships and your ladyship, it doesn't mention the 37.5. You would see, ensemble la nue propriété d'une maison en bloc, etc. So in the translation would be...
Where are you reading?
Page 193, three-quarters of the way down, page line 24.
At the 21, rather.
Anyway, that refers to a house.
23, yeah.
And it's translated...
So the father...
393.
393.
Yes, thank you. We've got the translation at page 393.
It's over on the next page.
Yes, my lord.
And there's a reference there to a house, but as you accept, it doesn't refer to the 37 purchase.
Yes, of course, yes.
Thank you.
So a big house was being built there, and this is why they are claiming that by that title, they have always been the owner of the 87.5 purchase, that would include the 37.5 purchase, and there was a dispute regarding the case and all that, so I won't come back on that again, my lord. And whereas the possessory action didn't decide, it's just for the harvest, because if somebody is owner of a land, somebody comes and plant on that or put anything on that, any object on that, the one claiming to be the owner cannot destroy it, except with an order of the court.
Yes, the title over the possessory action didn't depend on the plaintiff being an owner. Your point is the 1982 judgment doesn't establish anything about ownership. Is that right?
No, it just decided who were planting the sugarcane and who could reap the sugarcane.
Yeah.
But that was in 1982.
Yeah.
That was in 1982 after the affidavit of prescription was submitted. And as we say, that there was an interruption of ownership. And even this would be considered ultimately by the plaintiff in court. But then if we look at page 189, where you have one Mr. Gaddafi, it's not a memorandum of survey.
189.
And that's only, yes, 189, please, my lord. That's the rapport des constats. Rapport des constats is not a memorandum of survey as per the Land Surveyors Act. Land Surveyors Act have very strict conditions for the survey of land, and especially for the purpose of prescription. Not only the Affidavit Prescriptions Act and also the Land Surveyors Act, and also in court, in order to establish ownership, if you have to produce, it should be a full-fledged memorandum survey with all the formalities and procedures and technicalities. But there's no need for me to go on this. If you look at the Rapport des Constats, it says about the land, a portion of land occupied for more than 13 years by the said plaintiff, that is Mr. Sadanan Seebun. So more than 30 years, and the constat was in 2007. So 2007, 30 years, it brings us back to 77, whereas the father passed away in 1979. And that was just a few days before his death that he gave authorization for the plaintiff to occupy one land found in Cantorel. We don't know whether it was all his land, I'm sorry, my lord, all his land found at Cantorel. So this one says, give the lie to what the plaintiff was claiming. He says, and we see that Krishnauti Domun is on the side plan there, but then the area in question is not too sure. So all this is in dispute, my lord. This is why we are saying, taken with other matters, therefore, the defendants have been able to discharge their burden of establishing that their objections as filed was genuine, and they've supported that as they maintain in the court below. Whereas I've already addressed your ladyships and your lordships regarding the various shortcomings, not only regarding the affidavit of prescription, but regarding the occupation also. If you have to establish ownership by prescription, you should say with precision when the date of the occupation and possession starts and when the 30 years are reckoned. Whether it be by affidavit of prescription, and there it is spelled out in the law that you should state the date, up to 1 day. 1 day short would be bad. So here, we are not certain. We don't know. There have been various suggestions on behalf of the plaintiff. Suggestions by Ramanan Seebun, the Len Cooperative Society. Then there has been the suggestion by Mr. Jalal Anan, representing the SIFB, and he would say in evidence, if you would see the evidence of Jalal Anan, he would say that the representative of the SIFB producing his document, he would say that as from 1964. So was it 54, 64 with interruptions in between, and then after 64 with more interruptions again, and then we see the challenge being made by the Domun as per the title deed. So when is the date of the prescription starting? Then in this state of affairs, with this state of affairs, in this state of confusion, we have counsel on behalf of the plaintiff at page 29, if I may, my lord, and your ladyships, page 29, as from line 21, as from line 25, 23, 24, Mr. Jadu states that he had asked for certified copies and not the original. He moves that certified copies of the following documents be produced A and B, C and F. Document A is a receipt made in favor of Kewal. He has allegedly bought the land. So late Kawal has allegedly bought the land from somebody, and from that date onwards, he has been in occupation of the land. This is the starting point of occupation. And this is the point sought to be proved by producing these documents. So, then, rightly so, their lordship and ladyship before the Court of Civil Appeal asking the question, if this is the case, you should have gone by the short prescription. Title plus 10 years. In those days, maybe 20 years, but title plus 20 years, that's the short prescription. If you're already owner, you cannot prescribe. You cannot say that I'm prescribing the land of which I am the owner. If I may also, your ladyships and your worship, refer to page 233 of the brief, where
sorry,
again,
can I just
now we are before.
Sorry.
Yes.
Could I just ask you about page 29? That matter is in front of the Honourable Belanci. What was the proceeding in front of him or her?
Because the case came on a few occasions, my lady. The case was called before another bench, Honorable Balanci, who is now currently the Chief Justice. So that was when the case was coming for trial, and then there was a motion, a point of law that was taken. So
yes, that
therefore,
was the
the
first
case
abortive
was.
trial. That was an abortive trial, and then it was adjourned, and it came on again in 2011.
Yes, yep. Of course, yes, on a few occasions. Then there was the amendment to the plaint and so on. So if I may now refer, I was saying page 233. So we are now before the Court of Civil Appeal. And it is interesting to read the exchanges between counsel for the respondent, that is the appellant now. Before the court, I would refer to 233 at the bottom. I have Mr. Jadu, counsel for the respondent before the Court of Civil Appeal. I have considered that the fact the learned judge said that it should be transcribed, he was wrong. But the case of the respondent is only not based on the affidavit of prescription, but actual occupation, and we have evidence to that effect since 1954 up to etc. And then the court would refer him that about the question of action personnel and action in rem. Then we have again, if I may refer to page 241 this time. Just before line 20, Mr. Jaddu submits, Your Lordships, the first point I would like to make is that the action is based not on the affidavit of prescription. There seems to be confusion. This action is not based on the affidavit of prescription. Let's go through the plaint and show you. And he did that exercise to show to the Court of Civil Appeal that the prayer in paragraph 9b has got nothing to do with the affidavit of prescription. As I stated earlier on, we beg to differ on this interpretation, and that in fact all the prayer was based on the affidavit of prescription. And so I have also, if I may refer to page 255, again, my learned friend Jadu for the respondent before the Court of Civil Appeal, about 13th or 14th line, Mr. Jadu, at the time the affidavit was sworn, the 30 years requirement was not satisfied at that material time. So there is a lot of confusion on the part of the plaintiff before the trial court and also before the Court of Civil Appeal. And then we have the conclusion of the Court of Civil Appeal as per the judgment. Now, of course, the judgment also, which is at page, I would refer page 265 to 266. This is after we had drawn, if I may, my lord, the last paragraph. It is after we had drawn the attention of learned counsel for the respondent to the fact that first, neither the affidavit of prescription nor the objections made in 1976 were produced before the trial court. Secondly, that other heirs were not parties to the case. And thirdly, the action had not been brought in the presence of the conservator of mortgages. So for that purpose, my lord and my lady, as I did in my written case, and again, I took it up yesterday in the additional submission following the various questions, I would refer to the case of Radhakisun against Radhakisun, which is attached to the letter we sent yesterday, and also to, this is the last judgment in our list of cases. It is found at page in fact, it's the last page of the bundle that we submitted in our written updated written case, page 914, 915, also attached to the letter. So, in the case of Radhakisun, there, the last paragraph, there was a last prayer in which an order was sought directing the conservator of mortgages to make appropriate entries in his books as a result of this judgment. This prayer is misconceived. Along the same line as ruled by the Court of Civil Appeal in this case, this prayer is misconceived for two reasons. First, the conservator of mortgages was not made a party to the proceedings, and secondly, that case was under the Transcription of Mortgages Act, that is the transcription of an order, a court order, to establish title. But that was not done within the delay, appropriate delay. Therefore, the case could not stand. So, my lord, we can see throughout the evidence that the plaintiff, appellant now, will be just swapping from one foot to the other. So what is that cause of action? And I humbly submit, with all due respect, it cannot be for a plaintiff, the cause of action, to establish my ownership for 30 years of prescription, when we are not sure, as I've said, regarding the requisites that have been satisfied. There have been all the time contests from the neighbor. But then, if we look at the prayers of the plaintiff, it is found at page 98. I don't know the equivalent page translation. 98. At page 98, I want to find the equivalent English translation. Yes, unfortunately, I'm going by the record. You have it in. I'm sorry, my lord, if it's only this morning I got.
Never mind. We'll do our best. What are we looking for, Mr. Dolu?
Yes. I haven't been able to work on the MS document, my
but on
lord.
page
Well, this morning I got.
What are you looking at page 98?
page 98, the prayer being made by the plaintiff in the court below. It starts as page 10 at page 98, and then he recites his prayer. What was he
This is an
praying?
extract from the evidence. This is an extract
Pardon?
from the evidence. Is that what you're looking at?
Oh yes, the evidence. The plaintiff was deponing at the conclusion of the plaintiff's deposition. So he asked, as per his plaint, he was praying the court, he's making his prayer to the court, as per his plaint. Vous avez vu la page anglais? I understand it is at page 344, my lord. I would not like to translate it myself. Yes.
Yes. So 344.
346 rather, my lord. 346. Yeah. Yes. At line 10.
Yes.
So, and it is that very prescription that today the defendants, the Domun family and Bansalal family, are doing. So you are saying that those objections, the objections must be set aside again. You are therefore praying the court for a judgment, decreeing that Leka Kewal was occupying the said land. After you started occupying, you continued to occupy. Leka Kewal and his heirs have become owner of the land by prescription, and you are asking that the affidavit of prescription be transcribed by the conservator of mortgages, and you are also praying for a judgment ordering the defendants not to interfere with your possession. So in a nutshell, that was the case before the learned trial judge. And that was the case also that came up on appeal. And the defendants joined issue on that. Maybe I do concede, my lord and my lady, that the evidence that they have adduced was not that commendable. But they highlighted, as per the title deed, what they've been doing. Of course, they should have brought more concrete evidence regarding situation of building, sugar canes, which part was being, but small village of Cantorel, and we are here appearing for them, and we submit that the whole case was about that affidavit of prescription. And this is why the learned judge and the learned judges at the Court of Civil Appeal, they pronounced themselves on these, and they said that the conservator of mortgage should have been joined as a party, that there should have been the affidavit of prescription to give with precision all the elements required, the formalities required as per the Affidavit of Prescriptions Act. And if you are claiming that they have become owners, the parties should have been joined. And here, my lord, my lady, if I may refer to the deposition of the plaintiff, Mr. Seebun, in the court below. I stand corrected, of course, by what I'm saying, but during the recess, I will look very quickly, because that was a pertinent question, when my learned friend said that the brother and the sister was aware of the case, was fully involved in the case, but there's no evidence as to that. And also, we have evidence that when Seebun was deposing in court under solemn affirmation, at no time, I haven't seen, I said I stand corrected, at no time did he say that he was representing them also. At no time, there's no mandate. There's no procuration or proxy, as we say, that he was representing them in order to claim ownership of that land on their behalf. So, my lord, I would like to refer to some of the authorities. There, I have taken the liberty to quote exhaustively from the case of Floridor against Nalgota, the very first case law that is found in the bundle of primary authorities at page 29.
Sorry, where have you quoted from this? You say you've quoted from this authority somewhere.
In my written case, my lord.
Yes.
In my written case,
which paragraph?
I quote extensively three.
I mean, maybe it's paragraph 8A, Floridor. And
yes.
Yes. Yeah.
Yes. You see, why I did that, my lord, because the appellant seems to be relying on this and other case law that would refer consistently to this case. This is why I said that that case is a different case, my lord. In that case, it was a case of revendication, of mesures conservatoires, etc. And then the question of prescription was raised. And the court had to decide to choose between title deed and prescription. And if I may go to the case itself in the bundle of authorities, page 29 to 32, yes. So I've quoted the part that is found at page 30, where I've shown how there's this presumption legal, the case is authority for the question where the plaintiff was trying to claim that he was entitled to the land. And then you would see at page 31, at the very top, the question of the title deed. What? When there is, the court has got a choice, either the plaintiff claiming ownership by prescription, or it is raised as a defense vis-à-vis a title. So we have a situation where a plaintiff is claiming ownership by title. Somebody says, no, I have prescribed, this is my affidavit of prescription, or I've been in possession or occupation. So in that case, the presumption goes in favor of occupation.
Yes, I'm sorry, Mr. Dollar, I'm not following this. You've referred us to this case called Floridor and Altoca, but I'm not clear why it's relevant, because here, certainly, Ms. Sukut is putting the case very much on occupation. You've made the point that that wasn't how it was put below, but then we've got that point. But why do we need, but you accept, as I understand it, that you could put your case on occupation if you can show the relevant period of occupation. So there's no issue about the law, is there? And I don't understand there to be any disagreement between you on the law.
Yeah, where the decision, yes, if I may, where the court has to decide between occupation and title deed, how the exercise is done. So if the person claims by title deed, he should establish ownership of his predecessors also.
Yes, but here she's relying on occupation, and that's what she's claiming. Yes. So this doesn't really help us, does it?
And the defendant is saying title.
Yes.
The whole land.
Well, that's the argument, but they're relying on occupation, and we understand what you say about that.
Yeah, if I may, my lord, the penultimate paragraph about ownership and non-usage. If you're owner, non-usage doesn't necessarily, for a while, doesn't necessarily exclude or put your ownership in jeopardy. So this is why I wanted to rehearse the main ratio decidendi in that case. And then also this would be taken up by other cases, my lord, And we have the case being referred by my learned friend, the case of Amjad against Ramlul. There also we have the same issue, but where the question is about whether they were taking mesures conservatoires or not. And similarly, well, I think there's no need for me to
I don't think there
go
is. I
through
think
those
we've got the point.
authorities. Yes.
But
And so the various authorities would be in a similar line, that is the comparison between title deed and ownership, and how ownership should be established, and then how the title, ownership by title, should be established. So in our humble submission, the respondents have been able to establish their ownership by title over the whole of the 87.5 purchase, where the 37.5 purchase is alleged to have been occupied by the appellant. And then also, of course, my lord, if I may, before concluding, if I may, I would refer to the various documents where it is not stated with precision whether that was the very same 37.5 purchase, where the sugar canes were coming, what were the boundaries, which land, it was not fully identified, and a lot of hearsay evidence was even the plaintiff about this. I will not go on everything, but I submit that we have answered also, unless your lordship would want me to come back again, to the various queries that were made recently as per the submission that we have made. So may I therefore thank your ladyship and your lordships for listening to me.
Thank you very much. I think Lord Hodge has a question he wants to ask.
The outcome of this case doesn't turn on it, but I do wish to get the benefit of your submission. I raised with your learned friend the question of Article 2269, which cuts down the application of the 30-year prescription on action réelle. And it there refers to an exception which doesn't apply for an action to vindicate ownership of an immeuble. Now, in the code as I understand it, the basic structure of Mauritian law, like other civil law systems, draws a very clear distinction between movable and immovable property, meuble and immeuble. But in certain contexts, it may be that the word immeuble refers to a building rather than the land itself. I mean, for example, in Article 516, it says, tous les biens sont meubles ou immeubles. So in that context, it's talking about a distinction between movable property and immovable property. As I understand the submission by Mrs. Seebun, she was asserting that immeuble in this context bore a narrower meaning of building. I just wanted to know from you, is there any case law to support the view that immeuble in 2269 doesn't refer to all immovable property, but refers only to buildings? If you don't know the answer, then perhaps this is something that could be submitted in writing afterwards.
Yes, my lord, if I may. Real property means the land and the building thereon. The building is a fixture. It forms part of the land. And immovable property, therefore, means that you cannot move. It is the land and the building, whereas meubles are furnitures which can be moved around. Therefore, any dispute as to property involves the land and, if ever there's building, the building also thereon.
Yes. Well, that indeed was my understanding. So you don't agree with Mrs. Seebun that 2269 is confined to buildings? It extends to land?
Yes.
Yes.
Most respectfully, my lord, I don't agree with my learned friend.
I will ask...
My lord, if I may,
yes.
If I may be given 1 minute, when I was referring to this article 2269, 2269, I'm sorry, 2269, this is l'action en revendication. But in action en revendication, you should already establish that you are owner. You must be an owner by title or by affidavit of prescription or whatever. Then you can represent the heirs of anybody. Seebun, the plaintiff, can come and represent all the siblings and all that without permission from them to take the mesures conservatoires, that is, to preserve the property of which they're already owner. And then when I was looking at this, I saw on the other page, page 2, there is Article 2233. But I forgot to say something about this, which says that to complete the prescription, you can join for the question of possession and occupation your authors, that is, your predecessors who've been occupying and all that.
So, I'm so sorry, which paragraph, which article?
Article 2235.
2235, thank you.
25. Pour compléter la prescription, on peut joindre à sa possession celle de son auteur. De quelle manière, etc., on lui est succédé, hein, soit à titre universel, that is, inheritance, or particulier, and so on and so forth. But when you're claiming occupation of your author, like Seebun is saying, my father, and then my granddad also was occupying, this should be averred in the plain, and in the case of an affidavit prescription, this also should be averred in order to show the beginning of the possession and occupation. But this is not the case here. Thank you, my lord.
Thank you very much indeed, Mr. Tolu. Right, Ms. Seebun, do you want to reply? Do you want to change positions?
Yes, my lord, I said not less.
Yes, my lords and my lady, I will start by replying to Lord Hodge's question with respect to Article 2269 of the Code Civil. In fact, earlier on, when I stated to immeuble, I have to rectify it. In 2269 would, as I read it now, after the break, is for the fact that all actions réelles would be prescribed by 30 years. And 2269 states that if we have entered a case in action en revendication, in that respect, in that type of action, the prescription time bar of 30 years will not apply. When the owner has been dispossessed of its property. Here, immeuble, I do not any further make it reference to only a building. Like, let's say, if we take it to the scenario like your lordship had mentioned. One has a house, it may be the land, and the house has a valid title. And there is a possessor who comes and starts utilizing the said property. In this particular case, when the owner already has a valid title, in this respect, in defense, it would be an action en revendication that the owner of the building will enter. And in this aspect, even if it comes after 60 years, the application of 2268 will not take place in the action of revendication.
Yes. Would that be confined to the circumstance where there had been actual dispossession, or would it also arise if you thought that dispossession was threatened? Would you still be able to raise an action en revendication to preserve your possession against the threat of dispossession?
I would then go and before the district court to establish my possession, because we have an application, action possessoire, and this can be established before the district court itself, which is a much easier course of action.
Yes, but would it be subject to the 30-year prescription? Or would it also be, would it also be excluded from that?
If the possessor has a valid title and is by way of an action en revendication, which unfortunately cannot be taken before, then it is not an action possessoire. An action en revendication is usually brought before the Supreme Court, yes, because we are going to the title, not an action possessoire. Then in this scenario, then it becomes an action en revendication, where it is disputing the claim of the other party. Then it is again, it would be in exception to the Article 2268.
So we read 2269 as covering not only where there's been actual dispossession, but threatened dispossession, in effect, is what you're saying.
It can be taken.
Yes, thank you.
Yes.
Sorry, how does that,
yes.
how does that have any application in the present case? Is that relevant?
In the present case, yes, no. In the present case, we are not. We as the plaintiff and the appellant, we have not come by way of an action en revendication. No. We are rather an action conservatoire. Where, the action conservatoire, we have taken the point when the issue has been raised that not all heirs have been included in the application. So this is what allowed the plaintiff to be able to proceed with the case, because in fact it is doing an action conservatoire, trying to preserve his right, which he is trying to establish that he has obtained by way of ownership of 30 years.
Well, how can I tell from the documents that this is an action conservatoire rather than an action in revindication? What in the documents shows that distinction, in the court documents?
Given that this is a plaint on behalf of the plaintiff and the appellant, it will not be an action en revendication to start with. My understanding is an action en revendication would be as a way of a defense and not by way of a plaint.
Well,
this would be my understanding at this stage,
my
lords.
That cannot be right, because you don't have extinctive prescription of a defence. The action réelle, it gets its status by the nature of the plaintiff's claim.
His lordship at the trial stage did consider that the issue of which type of action was being brought by the plaintiff, my lord, and he did when he quoted the case of Cloridonal Cota at page 165 of the brief.
So here's 165 of the bundle.
Of the bundle, yes.
Yes.
He did consider the case of Cloridor and Naltuca, whereby the case was referred to, but then he mentions about the fact that the title, he was not impressed by the mere fact that the defendant had raised the issue of holding the title, and hence stating that they have a proper title of the property. Naltuca, let me have. I'm having a look at the judgment of Naltuca, my lords.
Well,
yes.
the reason I'm questioning the distinction you're drawing is that one of the cases you founded on was the case of Chu Ping Fen.
Yes.
And there,
yes.
there the Chief Justice said that an action en revendication was an act of conservation by the co-owner. So he is drawing no distinction between the two types at all.
Yes, indeed, my lord. You are perfectly right, and it is indeed Chu Ping is the case that we rely on to say that this is the action that is being brought and is being relied upon by the appellant, whether he did it on his own name or on the name as he at that moment being an indivisaire.
Yes. So would you are you accepting that while you say this was an action conservatoire, it was also an action en revendication? It was both.
On the basis of Chu Ping, yes, my lords.
Yes. Thank you.
Yes.
Right. Well, now where do you want to go from there?
Yes, and there was one more question raised by Lord Hodge before the break, and that was with regard to Article 2244, my lord, whether the citation en justice, un commandement ou une saisie, would have stopped the prescription, and whether the objections taken to the affidavit amounts to a citation en justice, un commandement ou une saisie. I would humbly submit that the objections taken at this stage of the conservator mortgage does not amount to the citation en justice and a commandement ou une saisie as per Article 2244.
Yes. But that's not a critical point, because if we accept that the judge was entitled to say by 1976 the grandfather and the father had had sufficient prescriptive possession that the father became the owner, then the point doesn't arise. But you are saying that if you're correct, there was no interruption of prescription in 1976 at all.
Yes, because the moment that there is for the prescription, the Article 2229, my lord, mentions that in order to be able to prescribe, because we went for the prescription of the affidavit, il faut avoir une possession continue et non interrompue et paisible. The moment that there are objections that have been raised to this affidavit, it then becomes that the possession at that time is no more paisible.
But in 2229, so this may not matter at all to the particular outcome, but we are required to set out the law as clearly as we can. The reason that 2229 is relevant is because it refers to interruption. But then to understand what civil interruption is, we have to go to 2242 and 2244. And if civil...
In fact, my lord...
That's correct, isn't it? And if under 2244, the expressions there, a court summons, a command, or a seizure, if the objection doesn't come within that, on what basis do we say that prescription was interrupted?
Yes, in fact, my lord, I'm grateful to your lordship for highlighting this point. And in fact, I think that your lordship is very right to say that the objections raised do not put an interruption to the possession of the plaintiff and appellant as at 1976, and therefore the possession carries on because they never put the appellant on by way of a citation en justice or by way of a commandement ou une saisie to stop the possession of the appellant and the plaintiff.
Given that this hasn't been argued, it would not be a basis of deciding this case. You can understand that. But I just wanted to be clear what your position was, yes. So that I don't misstate that. Ultimately, the case that you fought below was that by 1976 you had adequate acquisitive prescription. Yes. Fine. Thank you very much on that.
Well, thank you for that. If either of you want to add anything on that aspect of the law, even if it's not directly relevant to this case, by all means do so by a note submitted within a week. But I think we've got enough for our purposes.
Thank you.
Now, can we go back to your substantive case, Ms. Seebun? And can you help me on this?
Indeed.
We were referred by Mr. Dolu to page 255 in the judgment in the proceedings before the civil court, the Court of Appeal, and Mr. Jadoo was talking about the time limit. Do you have this on page 255 in the middle? At the time the affidavit was sworn, that's 1976, the 30-year requirement was not satisfied at that material time. If we freeze the time at that time, the affidavit was sworn, the condition was not satisfied. That is why I'm saying the case is not based on the affidavit of prescription, but an actual occupation, and this is an action conservatoire. Now, there the case seems to be, I mean, you've been putting your case very much on the basis that the judge found that it was satisfied by 1976. But there may be a little confusion in the sense that Mr. Jadoo seems to have been taking a rather different line before the Court of Appeal. Do you want to comment on that?
Yes. Yes, indeed. In one of the previous written case, my lord, when Mr. Jadoo had submitted the written case to the board, he had made a statement that one should not be relying as to his statement he made in court on that day, and but be that as it is, the 30 years requirement has been satisfied, my lord, as per the appellant and the basis of the evidence that have been brought before the trial judge. What I presume Mr. Jadoo may have been thinking at that moment in time was that in 1976, the requirement of 30 years was not needed, and therefore it may have been, I'm utilizing the words may, my lords and my lady, that it may have been that he replied that the 30 years requirement was not satisfied for the simple reason that only 20 years was needed as per the then law of prescription.
Right. That's one possibility. The other possibility is Mr. Jadoo simply got it wrong.
In the calculation of the years?
No, because the judge at first instance decision is perfectly clear that he had decided that there was 30 years prescription by 1976 by virtue of the possession of the grandfather and the father. So yes. Mr. Jadoo's concession may have misled the Court of Appeal, but it clearly wasn't consistent with the judge's finding.
Right.
Yes,
I thought I'd put it
indeed,
to you because of the point that Mr. Dolu drew our attention to. Now, do you want to say anything else, Ms. Seebun?
Yes, my lord. I have, since we are talking about the 30 years and whether it has been satisfied or not, and also my friend has pointed out the document where the counsel Jadoo stated that this is the time when the Leka Kawal started occupying the property, and that was in the proceeding before Judge Balancy, which is at page 29, I presume.
Yes, but this was not part of the trial.
Yes. The document yes, it was not produced. It was meant to be produced once they had obtained certified copies from Mocha Court, Malady. And however, that document was not produced, and we have submitted a document was filed on the 16th of July, whereby after having gone through the file, because I was not the counsel before, I wrote to District Court of Mocha in order to obtain copy of the certified document. And in the bundle of the documents that we have submitted to your lordships and your lady, we have a copy of the document, which we have and we have translated same. And it mentions in the said document, my lady, your lordships, that the property was in fact, the document bears dates of 1933 and 1943, and that one particular person had, in a sort of acknowledgement of paying of debt, granted the right to late Pitamba Kowal to utilize and use the property and step in his own
we
rights.
can't start going into new evidence now, Ms. Sukun. I mean, we've got the evidence.
Yes.
I'm afraid you're going to have to stand on that.
Yes.
You can't start getting new documents in now.
Absolutely not.
It was simply because we've been able to obtain, I mean, Mocha Court destroyed the documents and we thought if ever, in the best interest of justice,
Right,
if ever that could assist your lordship. Just to move on slightly, my lords, very briefly and quickly also, my friend stated that the boundaries of the disputed 37 3/4 purchase have not been rightly placed in the plaintiff's summons. My lord, if I may, the memorandum of survey which has been described at paragraph 2 of the plaintiff's summons at page 37 of the brief, indeed one boundary on the fourth side, the name of Kelawan Jaman appeared. The appellant would humbly submit, my lord, that the name Jaman is a typing mistake.
Yes.
When we look at it is Kelawan Duman. And when we look at the document J, the land surveyor's report, which, and there were questions were asked, demand of particulars.
Which page is that on?
Yes. Yes, okay. The demand of particulars was made at page...
No, the plan, you're referring us to the survey. Yes. Which page is that on?
Yes.
389,
yes, my lord.
Is that right?
It is...
Memorandum of survey document
389,
J.
indeed, my lord. 389, yes. Thank you very much, my lord. At page 389, when we read the memorandum of survey and the adjoining owners, on the very first paragraph, line 8, my lords, my lady, the adjoining owners, Mr. Deodat Padarat and Mr. Kelawan Duman, my lord, my lady, and the inside near line 20, and on the fourth and last side by Kelawan Duman.
Yes. So you say it's simply a mistake.
Yeah. Right. It is simple mistake. Even the trial judge raised the point that there was the issue of Kelawan Jaman, and Jaman was nowhere to be heard or known in the neighborhood, and he satisfied himself by the report of Mr. Koirati But it is our humble submission that it's only the name was wrongly typed. Domun became German and caused some doubts as to whether we were referring to the same property. In fact, it's the same property that is being referred to, my lord. And
we see, if we go to page 179, we see the plan which was attached to that document, don't we? And I think page...
And on the plan, indeed.
Yes, all right. Well,
and
we got
on the
that
plan,
point.
it is...
Thank you. Anything else?
Thank you, my lord. About the issue of the house, it's just that one Mr. Seebun, there was a question, and Mr. Seebun also at page 335 of his deposition is the old gentleman at page 335 when he was questioned, Mr. Ramanan Seebun, on the very top page, that he knew the property very well and that Pitamba was occupying the property continuously, and whether apart from sugarcane, to a question, was there also other things, for example, is there a house? And the answer was no, there is none.
Thank you.
In addition, my lord, there have been repetitively, my learned friend has stated that defendant had joined issue. After an amended plaintiff summons is produced before the court, my lord, if there are any elements that have to be pleaded further, it is up to the parties to request for further particulars and even to put up an amended plea. And in this case, none of these were done, my lord and my lady. I would simply refer your lordship to the judgment of Esplacatos, which is found at page 128 of the primary authorities. To establish the element of action, the indivisaire and the acquisitive right, my lord. In this case, at page 128,
Yes.
yes, in this matter, the heirs of Aurelia, one of the parties, were not even appeared to the court, even not to have given their assent to the wishes expressed by the person who was before the court, even though on the next paragraph, their lordship stated that at any rate, even an indivisaire is entitled to claim damages if he succeeds in making out his claim and in his individual capacity, my lord. Based on these submissions, my lord, my lady, I would respectfully submit that the judgment of the trial court be upheld.
Thank you very much. Anything else?
Just request
Yes. Well, perhaps you'd like to put that point.
You have said, Mrs. Seebun, that the co-heirs are aware of the action and they consent to it. Now, even if an indivisaire is entitled to raise this action, conservatoire, as you designated, what you're seeking to achieve is a declaration that they are property owners. Now, with the ownership of property can come obligations as well as privileges, as well as rights. Would it be possible for you to produce to the court within a realistic timescale a letter from the two co-heirs certifying
Yes.
that they have consented to what has been done? because if that is done, we can clear the air on that point anyway. Is that?
Yes, indeed, my lord.
What sort of timescale is feasible? What sort of timescale is feasible?
We are Wednesday today, by Friday.
Are they both resident in Mauritius?
Yes. This is what I was thinking, whether they are both in, if they are in Mauritius, it should not be a difficulty, my lord. We should be able to obtain same, I would say, a week. If they are not in Mauritius, we will definitely let you know as soon as possible, latest in the afternoon, even today itself.
Did you want to say something, Mr. Corrie, on that?
Yes.
Yes. Can you do it with...
Yes, my lord, my lady, if I may, in the last request of the committee, unfortunately, just now, my instructing attorney and myself check about the 2 children that have been mentioned, whether they know about them and all that. But our instructions just now, I didn't want to raise it because we don't adduce evidence at this stage, but my information is that there are more than 3 children, late Kewal. So if this is allowed, so I'll have to go to the civil status in order to see what is the position regarding the heirs of late Kewal, because this plaintiff has changed his name and has got the property, all the property being allowed to occupy, or the deceased father and mother. So we'll have to, in all fairness, if I may, I don't want to proceed accordingly, but being given the situation now and being given the instructions that my instructing attorney and myself just got from the Domun, so I'm taken aback now.
Well, I think we'd better, Ms. Sukun,
yes.
Can you, we'll give you 14 days to put in whatever consents you feel able to do with something to indicate that they are all the relevant heirs. Now, you'll have to show that, obviously, to Mr. Golu, and he may want to object. But I think, for the moment, we'll have to proceed on the basis of the way the case has been presented, and it may be that, as a result, we'll not be able to give you, even if we're with you on the main points, the orders you require. But I don't think we can take up time with it now, because it would be unfair to Mr. Golu to do that. So...
yes, my lord. If I may, my lord, on the demand of particulars, we had communicated the death certificate and the affidavit de notoriété of late Lekha Kawal as far as back February 2003. And there have never been any contest about same acte de notoriété. However, we will nevertheless be asking same from the appellant.
Yes.
And they have been provided to the defendant, then respondent today.
You can found in any event on the rule which says that a non-joinder is not fatal to the claim. But you can see why it would assist the court to know that people who might theoretically incur obligations by virtue of ownership should consent to this process.
Just on that, if I could draw attention to page 37, paragraph 1 of the plaint specifically pleaded who the sole heirs were. So whilst it would be interesting to know if there are other people in the background, it seems not to have been an issue in the case, so far as I'm aware, but that there were just the 3 heirs. Is that right?
Yes. Yes, indeed. They are Atmaram Kawal and Sita Devi Singh Kawal, my lord, my lady.
Right. Well, I think we have to leave it there. I think we will proceed on the basis of the material we have and your submissions. We will... Do you want the consent?
I think I'd like consent of at least of these 2.
Yes, well, I think if you can obtain the consent of at least these 2 heirs and submit that by within a week of today, if you need more time, you'd better let us know how much and why. And obviously, anything you put in, if Mr. Gollo wants to make any comments on it, he can do that within a week of seeing your material. But for the time being, we'll deal with the case on the material that is before us. Okay?
Thank you very much, my lord. Thank you very much, my lady.
And thank you all very much, both those who we've seen and particularly for conducting the proceedings in this way at several thousand miles distant. You feel as if you're just in front of us. I hope it hasn't disadvantaged you. It certainly hasn't disadvantaged us. And we will take time to consider our judgment and make our decision then as soon as we can. So thank you all very much indeed.
Thank you.